appreciate the invitation. I appreciate the conference. I've thoroughly enjoyed it. I'm so delighted that Patty Limerick started off. I figured I had to be here to hear her and talk about the integrity of this keynote speaker. She's still here. And thanks for setting the tone, Patty. I think we need a blessing, a prayer, and a celebration after what we heard earlier today. So I'm going to deliver that. And it's a poem by Tapa Hanzo, a great Navajo poet. And I knew I had to read this when I heard Stanley Pollack talk yesterday and meet his Navajo clients today at lunch. Patty talked about lunch and dancing, and I think she had some prayer in there too. So listen to this great Navajo poet. And of course the Navajo came out of the earth and have been there much longer than the rest of us. Before this, now remember the title of this poem is Remember the Things They Told Us. It's from her book, The Women Are Singing. And certainly we've heard some women singing the past couple of days. And it wasn't always true of the water community. Before this world existed, the holy people made themselves visible by becoming the clouds, sun, moon, trees, bodies of water, thunder, rain, snow, and other aspects of this world we live in. That way, they said, we would never be alone. So it is possible to talk to them and pray no matter where we are and how we feel. We are their little ones. Since the beginning, the people have gone outdoors at dawn to pray. The morning light represents knowledge and mental awareness. With the dawn come the holy ones who bring blessings and daily gifts because they are grateful when we remember them. When you were born and took your first breath, different colors and different kinds of wind entered through your fingertips and the whirl on the top of your head. Within us, as we breathe, are the light breezes that cool a summer afternoon. Within us, the tumbling winds that precede rain. Within us, sheets of hard thundering rain. Within us, dust-filled blares of wind that sweep in from the mountains. Within us, gentle night flutters that lull us to sleep. To see this, blow on your hand now. Each sound we make evokes the power of these winds, and we are at once gentle and powerful. Now, how's this for a desert people? Celebrating the wind, the sun, the rain, the land they live on, the creation, all Native American myths, and all myths of creation, and myths are stories. They are stories, they are metaphors about where we come from and who we are. Myth does not mean false, of course. So the natural resources of this great Southwest are clearly spoken of by Tapa Hanzo here. And I think there's also a message to each of us who have been here these past 2 days. We can be gentle and powerful. I like to remind lawyers that they can do that too. Lawyers at their best are counselors and problem solvers. When they have to be advocates, they will be advocates. I'm a judge. I have to judge cases based on hearing the facts, hearing the law, and making a judgment. Fortunately, I'm on a collegial, multi-judge court where it takes at least 3 other votes, so I can't simply decide what the law is going to be. But we will look to the Constitution, we will look to the statutes, we'll look to the common law, we'll look to case precedent, and we don't have the luxury of dodging the decision. And of course, the science, the hydrology, the engineering, the biology, the modeling, all these disciplines now that have grown up with this profession, particularly in the past 30 or 35 years, where we've had the privilege of being the stewards in our time and also those who have to take what's come before and see if we can live with it and pass it on, you know, without killing it. And I'm talking too about the historical and legal structure we come from. So any adaptation or change is built solidly on the expectations of society and the changing customs and values of the people expressed, here we're talking, in water policy and law. And I don't want to undersell the fact that when these disputes go to court, they are going to be decided by judges who will have to decide them and will depend on the credibility of the professions, the credibility of the attorneys, the credibility of the experts, the credibility of the trial judges, because appellate judges can only look at the record that's made in the proceeding, can't call people up and say, hey, David, what do you think? You know, when the oral argument closes, you then go to the books, you go to the record, you decide the case. So we don't have the luxury of telling the litigants, by the way, come back in another year when you've done another study. Well, we're going to decide the case. So this is the great virtue of the legal system. It prompts people, as we heard for the past 2 days, to talk, negotiate, solve problems within the legal framework, and then get the next increment of progress. Now, I heard a couple of things from Patty and Connie, and my poem is nowhere near Lucy Tapa Hanzo's poem, but I'm going to read it anyway. Guilt and redemption will continue in a minute. Remnants are lying around the forest. Wow. Talk about some metaphors. So Connie Woodhouse reminds us that old remnants are lying around the forest. These remnants are older than the living conifers. Both the living and the dead provide evidence of what precedes and what may yet to be. Conifers are good at feeling wounds. They generate sap to fill the holes. Patty Limerick reminds us that we can choose to be the sap that helps to heal wounds worth healing, or we may be the saps. A smug sap blames the tree for being sick. A smug sap blames the tree for being sick, while the healing sap will plug the hole against disease so the whole magnificent being, root and branch, may continue to bud. Now, what am I talking about? The Colorado River Compact, as an expression of federalism, is the subject of the poem, of course. So we live with metaphors, and I often think that those models that we see are metaphors. Can they predict actual results? Okay, we can only look back and say what happened, and what I like is the fact that when you read the poems of Native Americans, they venerate their ancestors. Okay, so I'm going to venerate a few ancestors here. And it's going to go towards notions of sovereignty and constitution and law as the expression of the customs and values of the people. So how did we get to the compact? Well, we got to the compact because as a result of the settlement of the West, we decided to move west. Now, we encountered the Native Americans who were already here. Chief Justice John Marshall told us that they're nations. Now, the Supreme Court has declared that they are dependent nations. However, they had an aspect of sovereignty and still do, some of which is being restored after not being recognized for a very long time. The sovereignty, of course, of the United States, the Supremacy Clause, the Property Clause, the Commerce Clause, we're well familiar with them, and 50 states. And, of course, the reserved powers of the states, because the government, the national government, only got those powers stated in the Constitution, I'm going to say necessarily implied. So now, this great public domain of the West, we know where it came from, the Louisiana Purchase of 1803, the Treaty of Guadalupe Hidalgo of 1845, and the Great Northwest Treaty, I think it's 1846, more or less, Patty? 1848, and then the Northwest is? There we go. Okay, thank you. When I'm with a practicing historian, I want to get the dates right. Okay, so we know this land comes in. We know it's the great public domain. We know that the tribes have rights, but they're heavily stressed, and the legacy of dealing with the tribes is not a legacy that we can be proud of all the time in our history. Because certainly the West involved the thirst for free land under the Homestead Act and for the resources on the public domain, and we engaged our government in negotiating with the tribes under duress to carve up pieces of land we call reservations and let us cede to the public domain territory which could be homesteaded and acquired. So that That is our legacy. But we have within these communities now, and that's why I love Stan's slide there. You take a look at the Navajo Nation bordered by their 4 sacred mountains, Hesperus, Blanca, Taylor, and the San Francisco Peaks, which is right on their flag, and think about how that bridges the upper basin and the lower basin, and think about the winner's case, the reservation of water, which turns out to be a senior priority, while the settlers were developing water under state and federal law. Federal law. Let me remind you, what was the federal law that allowed the states and territories to have the water to create water rights in? We know the Mining Act and a series of acts allowed the territories and the states to create water use rights under their own laws out of water severed from the public domain for that purpose, reserving now, as we know from the 1908 winner's case, the rights of the tribes. And those can include on-reservation and off-reservation rights depending on the terms of the treaties and the reservation. I won't go over all of that. The point is, some of the very much delayed justice is occurring in our time, and it has to do with the priority water rights of the Native Americans and their ability to realize wet water instead of paper water. Now, what did the compact framers do with that issue? You heard about it. They knew about the winner's case. 1922, 1908, Delph Carpenter was a lawyer from Colorado, former state senator, that when he was turned out of his office, his colleagues called upon him to be the interstate negotiator of compacts and the litigator of equitable apportionment decree cases in the U.S. Supreme Court. So I think that reservation for the Native American water rights was studied on the part of the commissioners, and so when they said nothing affects the Native American water rights, they left that to be decided. And as we know, that has taken a long time to come to fruition, quantification, and doing what you need to do with water, and that is build the infrastructure to use it. Because otherwise, water rights are theoretical. As you know, under the prior appropriation doctrine, the only true water right is a water right put to beneficial use. And so it is matured, perfected only by the amount of beneficial use. And we change water rights in the West, particularly in Colorado, the jurisdiction I'm familiar with. All you can change is a historic, beneficial, consumptive use. You can't convert the return flow or water that was wasted, was not utilized. You have to quantify the historic, beneficial, consumptive use. And that's all you can transfer. And that's done over a representative periods of years. The Native American water rights were set aside for the amount that they needed, either under the PIA standard or the Homeland Standard. So when you look at this compact, I think you have to read the language, which is what courts are going to do. So the Native American water rights are whatever they turn out to be. The negotiators couldn't do anything about that. I'm going to say the same thing about Mexico. They didn't have a platform to decide how much water Mexico would get, but you cannot read the transcript without seeing that they knew that some water at some time was going to go to Mexico. In fact, when they were trying to divide up the river based on agriculture only, which were the first 6 sessions of the sessions of the failed sessions that occurred in Washington, D.C. before they went to Bishop's Lodge, they were trying to figure out the irrigated acreage that could be made available in each of the states, and they came up with, water duty of 20 million acre feet to serve the acreage, and they included over 1 million acres of Mexican land in those calculations. So we know they were concerned about Mexico, but they took it off the table, realizing that they didn't have jurisdiction to deal with it. Congress had told them to deal with the matter of apportionment among the 7 basin states by enabling statute that put them at the table. And so they got their representatives, and they came to the negotiating sessions. Herbert Hoover, after suggesting that they break up the sessions after the 6, where they're trying to do it by acreage, polls the commissioners. They say, well, let's keep trying, there's too much at stake. So they end up in Bishop's Lodge. And, Hoover holds them there until they get an agreement. And Carpenter comes up with this idea. He called it based on nature. and a few other things. A careful study of the avoidance of equitable apportionment. And that's where the U.S. Supreme Court decides from time to time what the shares of states sharing an interstate river will be. And it's clear that equitable apportionment can be adjusted from time to time based on the relative equities. All right? Now, we found out in the Arkansas litigation in 1902 to 1907, which Colorado was involved, Arkansas River, Colorado was involved with Kansas. There were three theories asserted. Kansas was a riparian state, and they claimed that Colorado had to pass all the water down to Kansas because Kansas was Colorado all the way up the Arkansas before Colorado Territory was founded in 1861, which is correct. Kansas was founded in 1854, if I remember, as a territory. So Kansas wants to become a state in the Civil War, and Colorado is carved out of the headwaters of the four great rivers, the Arkansas, the Platte, the Rio Grande, and the Colorado River complex. Well, in the interstate litigation, the equitable apportionment litigation, Kansas claims all the water. Colorado claims all the water because it says we got in on the equal footing doctrine under our 1876 Constitution. We have prior appropriation. Therefore, whatever Kansas may get, after we use it, they get. And the third actor was the Bureau of Reclamation, which had been formed in 1902, as you know, and they claimed all the unappropriated water of the West was reserved by the Reclamation Act. Except that the Congress had put in Section 8 of the Act, which says that, basically, the rights for the reclamation project shall be obtained under state law. No reservation of all the water in the West to be built out according to the reclamation program. So here Colorado and the western states are with this doctrine of equitable apportionment with uncertainty. Okay? And Carpenter seizes on the compact clause, which had been used to adjust border disputes in the East, and decides that this is a treaty-making power that is shared by states and then can't go into effect unless approved by the United States Congress. So, treaties with Native Americans, treaties with the states. That's what we're talking about with a compact, I think. All right? So, what does Carpenter want to do, and what comes out to be the fruition of the compact? This is from Dan Tyler's great book, Silver Fox of the Rockies, the biography of Delph Carpenter. Carpenter's 50-50 plan was unique because instead of focusing on an equitable allocation of water to each state, it divided the states into two groups. The four upper states had to accept the burden of providing water to the three lower states. The three lower states would have to obligate themselves to an equitable division of the water they receive from the upper basin. In other words, forget about prior appropriation, first in time, first in right. In this scenario, each state was giving up some of its sovereignty to achieve collectively the desired goal of a dam and reservoir on the lower river. We know what that is, the Boulder Canyon Project Act, which California and the Imperial Valley were seeking as a priority matter. Colorado and the upper basin states did not want to see that happen until there was an apportionment of the water among the states. Because Carpenter, as Colorado's representative, had fought just as hard as the other state commissioners for an allocation that would meet all of Colorado's present and future needs, his 50-50 plan reflects a major shift in thinking. It emerged from an extensive study of the Constitution, the land surrounding the Colorado River, the urgency of California's need for protection, flood and sustained water, and the political exigencies of compact negotiation. In other words, hard bargaining. And so, he saw it as a natural funnel at Lee Ferry, that there was this great gift that nature had provided of the watersheds. Now, remember what Colorado's position was originally, was that there will always be return flow to the river, and the lower basin shouldn't have any kind of guarantee put on the upper basin, because we make our water uses. We're the headwater state. We contribute 70% of the water Colorado's watersheds do to the Colorado River. We ought to just be able to use it. And he used some idea of nations upstream and downstream to come out with that result. And, of course, they couldn't get to first base with the lower basin states. So Colorado has to live on 1/3 of the water it produces. That's the effect of the 9 interstate compacts and the 3 equitable apportionment decrees on the 4 great rivers that arise in Colorado. 1/3. Now that leaves a lot of stream flow, 2/3 that goes out of our state. That includes on the Colorado River complex. Now, Carpenter was not able to get the bargain that he wanted. What did he have to do? You know the story. 75 million acre-feet on a 10-year running average could not be withheld from the upper basin at the delivery point at Lee Ferry. Okay? He tried for a lower figure. He tried for 65. The lower basin wanted 85. Arizona wanted an annual guarantee. An annual guarantee. Well, the best that Carpenter could do was to roll it off to a 10-year running average. Now, were they dumb? Were they stupid? No, they were children of drought. There was an 1890s drought that Carpenter went through and these other compact negotiators. In the year 1902, there was only 9 million acre-feet virgin flow in the Colorado River. They were not dumb about drought. That's why the upper basin wanted some kind of leeway in the insistence on the lower basin that it would not agree to a compact unless there was some kind of guaranteed water supply for the lower basin. Now, I've had the chance to look at the Colorado State Archives, and I find an incredible map that was in there, and it turns out that Ralph Meeker, the state engineer who came into that room with Carpenter was probably his own lawyer, but he had Ward Bannister, the lawyer for the Denver Water Department, kind of shadowing him. But Meeker had a diagram that showed a 50 million acre-feet reservoir where the Glen Canyon Dam now is, on the charts in January of 1922 at the very first compact meeting. There was another reservoir sketched in, 31 million acre-feet. We know what that is now. It's the Hoover Dam. All right? As you know, the Rainbow Bridge and the legislation having to do the Colorado River Storage Project Act of '56 limited the elevation of Powell so that the Rainbow Bridge would not be damaged. So that ends up with what? About a 26 million acre pool instead of what the upper basin was looking at, which was 50 million acre feet. Okay, so this is the story of how the upper basin has had to scale back its wild fantasies. All right? So when we get to the development of the upper basin now, since the lower basin gets its reservoir at Boulder Canyon Dam, and the upper basin is looking at how do we equalize this situation and be able to continue the development of our compact entitlements, the apportionment of the river was made at Lee Ferry with each of the states basically to figure out what share they had. They couldn't get to that. There was not the climate there to be able to get the state apportionment. And as we know, the reason that it happened in the upper basin, and it happened after the 1930s drought, was because there was no way the upper basin could come anywhere near getting its apportionment without upstream storage for the delivery that the lower basin required as the price of this interstate apportionment, which the upper basin agreed to. All right? Carpenter said it would maybe be 150 years before Colorado would ever use its entire apportionment. The USGS had suggested a 50-year compact. We'll do it. There's a letter that I have here. It's very interesting that they sent to Hoover kind of through the back door and said, look, why don't you lay this out for us 50 years and then we'll see what happens. Carpenter, the upper basin, wasn't going for that, and the lower basin wasn't either. They wanted a perpetual apportionment. So now, to get the Colorado River Storage Project Act, they had to surmount the inevitable. And what was that? Water scarcity and drought. The 1930s drought had intervened. The Bureau put out a great book that had all the possible projects that could be built on the Colorado River, 134 of them. 134 of them. This is a 1947 report. In the upper basin, they had projects that would build out 9 million acre feet, but the introduction to this said, it looks to us like there's only 6 million acre feet for the upper basin to develop based on the hydrology as we now know it. Now, it seems to me you saw that 6 million acre feet up here when Don Osler was up here. So the upper basin effectively took a shortage as a result of the guarantee delivery. And what they did was, in light of the 30s drought, they then decided among themselves to share the river upper basin apportionments on a percentage basis, which is, again, a reflection that the water supply available, even after the building of storage, is going to not be what the upper basin expected it could be. So when you look at whether or not the law of the river has adapted within the framework of the compact, I would have to say yes. But it's adapted to provide this storage guarantee in both the upper and lower basin, which Herbert Hoover said in the very first line of the very first negotiating session. He said, we're here, the lower basin wants to get that storage vessel, we've got to get the river apportioned, and everybody realizes that storage is going to have to be built somewhere on the system. Why did they say that? They knew the hydrograph was like this and that. All right? And they didn't, even though there were flows of 20 to 24 million acre feet at some point, they didn't try to divide it up based on that. They did pick an average that isn't too high, and based on the science we've heard now and the hydrographs. So that is basically the story of how the government acceded to the states having a treaty among themselves for a perpetual apportionment of the waters of the Colorado River Basin. Does that mean we can ignore the acts of Congress that have been passed, like the Clean Water Act, the Endangered Species Act, the Federal Land Policy Management Act, NEPA? Absolutely not. Congress has the right to continue to legislate. Have we had to react to that within the state framework? Of course. Is there a mechanism for amending the compact? Yes. Let me read it to you. It's right in the compact. In the event that there's a dispute in the compact, should any claim or controversy arise between any two or more of the signatory states with respect to the waters of the Colorado River system not covered by the terms of this compact, over the meaning or performance of any of the terms of the compact, as to the allocation of the burdens incident to the performance of any article of the compact, or the delivery of waters as herein provided, as to the construction or operation of works within the Colorado River Basin to be situated in two or more states, or to be constructed in one state for the benefit of the other. That's an interesting phrase. Or as to the diversion of water in one state for the benefit of another state, the governors of the states affected, upon the request of one of them, shall forthwith appoint commissioners with power to consider and adjust such claim or controversy, subject to ratification by the legislatures of the states so affected. The compact shall be binding and obligatory when signed by the states. That's signed by the states. It was approved by Congress. Now, what is the message on this is that the framework is we need to work through our states and the Congress. That's the decision we have made as a people. Does that stop our First Amendment rights to advocate for change, different statutory provisions, all these modifications and adjustments we've heard about? I would suggest absolutely not. But to amend the compact has a very specific process which is very difficult to achieve because it requires the consent, in another article here, of the 7 signatories. Okay? Now, is this right, just, and equitable? I would argue to you, of course it is. Of course it is. Each of our states was set up so that we could have our own water law system and make our own choices. In Colorado now, we have in-stream flows. We have kayak flows. You told me 20 years ago that we were going to have kayak water rights. You know, it wouldn't have been admissible in this room. But we have in-stream flows on 8,500 miles of stream protected by the Water Conservation Board, a decision by our state Supreme Court that says it's a fiduciary obligation to enforce them. And do you know what they do? They hold the maintenance of the stream conditions against injury by changes or new water rights. So, in-stream flow, we decided this case 6 months ago. When you come in with an augmentation plan or a change of water right, you have to respect the in-stream flow. You cannot simply take the return flows that belong to back to the public resource and destroy or impair the in-stream flow. So there's nothing as good as a water right within our states, and there's nothing as good as an agreement between the states. And there's nothing as good as a good, healthy discussion that we've had in the past couple of days. But let's not be surprised that it ain't going to be easy to wrench the compact out of its foundation, right? Nor to change the way the Bureau of Reclamation has to enforce the law of those projects whose decrees were obtained under state law and are operated pursuant to an act of federal Congress. Now, there's plenty of stuff we can do on the river with management, but I don't think we can just go to the Bureau of Reclamation today and say, you know, don't operate Glen Canyon Dam for its authorized purpose. Okay? Now, I've heard some intriguing suggestions here, and one of them was that the upper basin states ought to be able to continue to develop, because the more they do, the less water there's going to be in Powell, and the more of these features will be uncovered in global warming. Now, make no mistake about this. The municipalities are going to serve their residents, particularly drinking water, which has always had the highest priority in human history. We're going to figure out how to do some restoration here. We're going to have the market work. It is working. In Colorado, we're over-appropriated in 3 of our 4 river basins, the Arkansas, the Platte, the Rio Grande. A little bit more water, that's going to be very expensive water to develop and very controversial within our state about when, if we should. But I'd like to say that under the compact, we have plenty of time for that discussion among ourselves. What we may not have plenty of time for is that we can't have the benefit of our apportionment. You know, that's off the table. So, you know, I think, unless there's a major change in the law. Now, I can't stand up here and, as a judge and say there's not going to be a major change in the law. I would think what we heard about the flexibility of the law of the river, however, and what we're going to hear from David is definitely a possibility and has been demonstrated in the midst of great stress during this drought. Now, you know Ian Fraser, great writer for the New Yorker, How to Operate the Shower Curtain. Any of you remember this? January 2007. We are happy to have you as our guest. There are many choices you could have made, but you are here, and we appreciate that. Operating the shower curtain is kind of tricky. Nobody is denying that. If you do not wish to deal with it, or if you would rather skip the whole subject for reasons you do not care to reveal, we accept your decision. You did not ask to be born. There is no need ever to touch the shower curtain again. If you would like to receive assistance, pound on the door, weep inconsolably, and someone will be along. The compact is a shower curtain. We're going to have to deal with it. And thereby, we're going to have to deal with each other. Thank you.